Good afternoon, everybody. I'm Anjali, your moderator for today, also heading the sales and marketing for MyLegal software. MyLegal software is a legal case management software that is created for the lawyers by the lawyers. Today is October 27th, and we are here with our weekly webinar. Today, we are going to talk about intellectual property challenges simplified for lawyers. In the webinar today, we'll offer a deep dive into intellectual property challenges and considerations that lawyers may face in their careers. How to identify exact issues and pinpoint solutions as per the need of your client. As a guest speaker for today, our first speaker is Mr. Larry Lozenthal, who is formerly an engineer and has been practicing intellectual property law since 2017. He counsels clients in all IP matters, including patents, trademarks, and copyrights. He started his career in BigLaw and Manhattan. He moved to boutique firms and then opened his solo practice in just over 2 years. He started his career in IP segment 2 years ago in 2020. Mr. Gehi was Larry's first client. Mr. Rosenthal is a Barrett in New York and New Jersey. But since IP law has federal jurisdiction, he is able to help clients across nation. Larry is based in Westfield, New Jersey, with his wife and two young children, aged 7 and 10. Hi, Larry.
Hi, Anjali. Thank you very much for the introduction. I've been practicing since 2007. I don't know if that was clear. It sounded like 2017. So.
Okay. Sorry, that was 2007.
Do you want me to start now, or are we going to do something?
You can just give a brief introduction about yourself and how you started, and then we can get started with the presentation if you want to present.
Sure. I think you hit most of the points. So I was an engineer. I was working at Apple in California, and I really didn't have any connection with clients, with people. And my dad was an attorney, and he had this great connection with his clients. I would go to a restaurant. We would go to a restaurant, and he'd introduce me to the owner, who happened to be his client, and it really had that personal touch. And I felt like that was missing in my career. So I went to law school. Graduated, and then the job opportunities for me in law were in intellectual property because of my background as an engineer. And people just saw that and said, you should do patent law. And I had no background in it, but it turned out to be a great career. Good offers and very interesting subject matter. What is fascinating about it is that I don't have to throw away my engineering degree to do this. Really, I needed to understand a lot of these inventions. And it keeps my mind fresh with new inventions, which is really fascinating. That was one of the things I really liked as being an engineer is working on new products that the world hadn't seen before. And then when I went to boutique firms is where I really got involved with a lot of the trademarks and copyrights, which was fascinating too. It was a different way to think about things. When you think about legally the differences there, it's quite interesting. So I was fortunate to have that broad experience, which led me to be able to open my own firm, as Anjali said, just over 2 years ago. And Mr. Gehi has been a valuable client since.
That's great. That's great to know, Larry. And welcome to all our audience and people who have just joined us. If you have any question related to intellectual property and how it can be useful for your clients, for your brands, for your businesses, you can put your questions down in the comment section below, and we'll be answering all your questions at the end of the session. So stay with us till the end. So Larry, I think we can get started with your presentation. I think you have something to show to our audience. And it's a request to all the audience that you can keep notes of whatever is being talked in the session today. And in case if you miss out, you can always go back and check our social media channels like LinkedIn, YouTube, Facebook, or Instagram, and you'll find all these sessions recorded there. So yes, Larry, we can get started with the presentation for today.
Thank you. I'm going to put up if everyone can see the slideshow, it's just really the name of my firm, that's my name, and the address. So what the goals of what I thought would be valuable to people here would be for attorneys. I understand there's a room full of attorneys, a room who might not come across intellectual properties issue every day, but your clients are dealing with intellectual property issues. In addition, you might have your own intellectual property issues, or maybe you don't know that you do have them. In other words, what can you as an attorney protect as far as the name of your law firm, the product you put out, and such. So I'm going to go over the differences among the forms of intellectual property. So at least you'll have some knowledge of it, and you can sound like you know a little something when you're talking with clients, and be able to spot some sort of intellectual property needs, which can be very valuable. And then how you protect your firm. So the four basic types, and you've probably all heard these terms, are patents, trademarks, copyrights, and trade secrets. And the jurisdiction, as Anjali mentioned, is federal, which is valuable for to keep things consistent across the U.S. and also benefits someone like me who would normally only be able to practice in New York and New Jersey. So let me just give right here, this screen here is the basics of what these protect. So a patent is what people think of when they say, I'm going to build a better mousetrap. I'm going to design a product that's going to sell a whole bunch of them, and it's going to be new, and I want to protect it. That's called the utility patent. Another type of patent that's popular is called the design patent, and this protects the ornamental design of an object, such as if you have a water bottle and it has a certain curvature to it or a certain look and feel, and you can protect the non-functional aspects, and that's called a design patent. There are other types like a plant patent and such. We're not going to talk about those. Those are much rarer, and you probably won't come across those. Now, a trademark is something that identifies the source of goods and services. So when you see a name, a symbol, a logo, or even a sound, let's think of the NBC chime. When you hear that, you know it's NBC, right? So a sound can be a trademark, and that identifies, you see that name or that logo, you know who made the object, who sells that service, and you know the quality of it just by associating. And that's the strength, that's the power of a good, strong trademark. Copyright are literary and artistic works, and some examples of those are books, music, and art. Now, a trade secret is sort of the opposite of those. In other words, a trade secret is just something that you keep to yourself. You might not want to tell anybody about it, so you're not really protecting it in the sense of getting a registration or obtaining a patent. You're just keeping it a secret. And you got to be very diligent in keeping that a secret to be able to protect them. Now, I'm going to go over briefly what each type of IP protects. When does your right in that intellectual property start? How long do you have that for? And how do you get that right? And they're a little different for each type. And it's important to understand the differences, or you could lose the rights. So patents. So the patent does not actually give you the right to make or practice the invention. It actually gives you the right to exclude other people from making or practicing an invention. So if somebody else wants to sell an object that you have patented, they need to either buy the patent from you or take a license from you, or risk being sued. And when does the rights for you accrue? And it really starts generally when your patent is issued by the United States Patent and Trademark Office, the USPTO. And it lasts for utility patent, it will last for 20 years. And a design patent is 15 years. So you got to be careful of that, right? If you're judging between a trade secret, which lasts as long as you keep it a secret, and a patent, which is only good for 20 years, there are balances about maybe you don't want to tell the world how you created your invention for only 20 years. Like Coca-Cola has its secret formula. They never got a patent on that because they didn't want to tell anybody what was in it. 100 years later, it's still a secret. So how do you obtain a patent? A patent is one of the more difficult types of IP to secure. A patent professional is recommended in this case because you need to draft a complicated specification that describes the invention in full detail to allow somebody who has skill in the art to be able to reproduce the invention and make what you had made. And that's the back and forth. You tell the world how to make your invention, and then you get the 20-year right to prevent others from using it. So this application has a full detail of how to make and use this invention, and then it has drawings that go along with it. And then you present that to the USPTO, and it can take 2 to 5 years for the USPTO to examine rigorously. The examiners who look at these are engineers or in pharmaceuticals or whatever field your invention is in, that they examine this and they understand the state of the art, and they're judging it on a few different prongs. The main two are your invention has to be novel, meaning it can't have been done before, and it has to be non-obvious, which means it can't just be you take somebody else's invention, make a little tweak to it, and suddenly you have a new invention. That's not going to fly either. It needs to be not obvious and novel. It also needs to meet certain subject matter eligibility, such as it can't be a perpetual machine because those don't exist. They're just theoretical. And like I said, it could take a few years because the examination is rigorous. There's a conversation with the examiner to discuss the issues that the examiner raised, and you have a chance to dispute that assertions by the examiner to say it would not have been obvious for various reasons, or this art that you cited against my patent doesn't do the same thing in the same way, so it's not really analogous. So for trademarks, so the trademark, like I said before, identifies the source of a good or a service. And so the trademark protects from other companies, other people from using a name or a trademark that is confusingly similar to yours. And part of that confusingly similar is not just the name, but also the goods and services. And it's a lot of prongs that are determined whether something is confusingly similar, but those are the two main ones. So, for example, there is Dove chocolate and there is Dove soap. And people, even though that's the exact same name, you're not going to confuse chocolate and soap, or at least I hope you don't, because that would leave a bad taste in your mouth. So if you are going to, so you don't want somebody to be using a mark that is similar to yours to confuse the public. The trademark laws are to protect the public from being fooled. So if they think they're buying a good from a reputable company and they're going to get a good quality, but they're buying it from somebody else because they were confused, the consumers, the public will be hurt. So that's where the trademark rights are important. But how do you get the trademark rights? In the US, there's common law rights in a trademark, which means when you start using your mark in commerce, advertising it, selling goods with your name on it, that's use in commerce, and you have rights as of the first date you started using it. Now, you get a lot of benefits for registration, getting a federal registration of your trademark, but you have rights accruing as soon as you start using it. And your rights last as long as you're using the mark. So I was working on a due diligence for some merger a few years ago, and I came across this old Pontiac trademark from the 1920s, and it's still good, right? They've been selling cars that long. So it doesn't run out and then everyone can start using your trademark. Like a patent, it's good really forever, as long as you continue to use it and continue to pay the USPTO every 10 years to renew the trademark and prove that you've been using it. Now, like I was saying, to obtain a federal registration, it goes through an examination process where you're going to submit your mark and how you identify your goods and services. And then the examiner will check a few boxes, make sure it meets the requirements. And one is that it cannot be confusingly similar to another mark that is already in the USPTO database. So the USPTO is not going to look at use of the mark at common law. So let's say there's a company in California and you're in New York and you've been using your mark for 5 years and you decide to get a trademark, federal trademark, and in the last 2 years somebody in California had started using the same name, the PTO is not going to know about that company in California. And if there's nothing else out there that on their register, they can give you a trademark registration. And then I'll go over the rights in a few minutes, but it's important to know the distinction between being able to obtain a registration and being able to use it in real life where there might be another company out there. And I'll explain that a little bit further. There are two basic bases. In other words, you don't have to actually be using your trademark to apply for a registration. Something called an intent to use application. If you have a bona fide intent to use a mark, you can file an application. And what this does is it might give you an earlier priority date against somebody who hears about your name before you get to register or use it. So it's important to get an earlier date. So for copyrights, analogous to trademarks, copyrights have common law. And this right prevents others from copying your work. A strange part of copyright law that people don't really think about is if somebody else creates the exact same thing that you created, I mean, that's going to be rare, right? That's going to be not really going to happen much, but it's theoretically possible. If somebody comes up with the exact same thing and never seen your work, never heard about it, there's no infringement there. The infringement has to be the copying of your work. But again, you don't want people to take your picture that you photographed or you drew or a book you wrote and then reprint it, republish it, and they can make money on it. So the copyright can protect that. Now, when do you get that copyright? As soon as you create it, as soon as you put pen to paper, you have a copyright. That doesn't give you a registration. That gives you common law rights. So as with trademarks, there are benefits to a copyright registration, and that registration does not undergo a rigorous examination by the Copyright Office. They basically check procedural issues and make sure it has, it's sufficiently creative is what it's called. It has to have some element of creativity to it. It can't just be a listing, like a phone book listing, because that's not creative. And you're not going to get a registration for that. Now, how long is a copyright good for? Generally, the life of the author plus 70 years. If it was created after 1978. Before 1978, it gets a lot murkier. They didn't codify a lot of the laws, and I'm not going to go over that right now. Now, trade secrets. Like I said, these are kind of opposite to patents, because the patent rights, you're telling the world how to do something, where a trade secret, you can prevent others from copying what you've done because they don't know about it. But it's very important you keep it a secret. If you're sloppy and you send your secrets to somebody, a contractor who's going to work on your products or your whatever you're doing, but there's no NDA in place, you've kind of lost your trade secret rights because there's nothing stopping them from sharing that with the world. And if you go to sue somebody, that might come up. So you really need to be diligent about your employment contracts that keep everything a secret, and NDAs. And like I said, you have to be diligent. And I mentioned before, Coke's secret formula. They didn't tell anybody, and they never would. Now, as I mentioned before, there are certain benefits of having a federal trademark registration, right? You can sue people in state court under common law rights, but it's much more difficult. So the federal registration will give you the exclusive right nationwide. And if you have a federal registration, that company in California wouldn't even be able to really start, because they would most likely know about your use, and that would, in the first instance, they would realize they would be dangerous for them to start using that name, so they wouldn't want to. And if they do, you can protect everywhere in the nation, because the federal registration gives notice to everybody, including the public. And like I said, it gives you greater advantages in court. It gives you, it's proof, evidence of having a trademark. If you go to a state court with common law rights, the first thing you have to do is prove that you have a trademark. You've been using it so long, but a paper that says you have the right since this date, right there, gets you into court. And you have certain remedies, and you can use federal statutes to go after infringers in any state. You also get, after 5 years, incontestable status, which means somebody can't try to cancel your trademark under most theories. The only one really left standing is under fraud at that point. And you get to use the circle R next to your name to tell everyone, listen, I have a registration. And it kind of carries a little weight. Now, I wanted to talk about copyright creation here, because it's a little tricky. If you hire, let's say you wanted to create an advertisement, like a nice drawing that you can use to advertise your products or your services, and you hire a contractor to do that, that contractor essentially owns the rights to it, unless you set that up properly. So generally, the author is whoever created the work. Now, there's exception to that, is a work made for hire. So if an employee is part of their regular duties, they, like a graphic designer in your company, works on this, then that ownership would inure to the company itself. And if
Larry, I have a question on that. I'm sorry to cut you. Very important
Sure.
question. Now,
Sure.
if that particular person that you're talking about is a contractor, and suppose if that person, is a contractor, you don't have a written agreement, don't you think that can open up a can of worms if there's no written agreement between the contractor and the person who actually shared the idea over here?
It can, and that's why it's important. And I was going to get to the last bullet point there, is if you don't have the rights to your work, then you don't have the right to stop other people from copying it, really, and you want to own that. So a work made for hire is, if you hire a contractor, you need, in the contract language that hires that person, you have to say, this is a work made for hire, those particular words. And then when they create that work, you're the owner of it. You can file for the registration. You can do what you want with it. You can license it and everything. If that didn't happen, you would need to get an assignment from the person who created it. And that's just a little bit more work. And if they don't agree to it, they're not going to assign it to you. So it's much better to upfront have the contract that you sign with the contractor say that it's a work for hire. I hope that answered your question.
Yes, perfect.
Okay. So now I want to get to the part about the, this is where your clients might have some IP needs. The name of their company might be something that's trademarkable or registerable. And this is important, like I said, so other people, a common complaint is somebody is using my name and they're confusing customers. Well, if their client can get a trademark registration, that would be very helpful. If they're developing any products, then you might consider patents to protect the products. Also a trademark, because each product might have a different name, and each of those could have a trademark. Let's say, for example, Nike, obviously the name of its company is trademarked, but the line of shoes called the Air line, Air Jordan, Air whatever, those are trademarked too. Those are the products, but those are all protected. So some other Reebok can't use an Air to sell their shoes. If a company sells multiple services or various products, again, different names, all can be protected. That could be under a trademark. And if your client creates any art, music, or literature, think about copyright protection. Make sure that that they have their contracts lined up if they're not the ones creating it, or if they're just a creative type who are making it. It's beneficial to register, because to sue somebody for copyright infringement, you need to have a registration. It's pretty short. You can get it in about 3 months, but once someone starts infringing, you can't sue them until you actually have that registration. When I say suing, it's kind of a harsh word, but that's basically what you're doing. They're developing a new court for small claims in copyrights. That's much easier than going with a full out battle in federal court. So that should make it easier. The damages are limited, but it make it much easier for small clients to get their claims across. Now, it's a good idea sometimes to have a freedom to operate patent search. This is if your client is selling products, maybe they import the products from another country and sell them here. Well, those might be protected by a patent you don't know about, and you're going to get sued. And they might sue the manufacturer too, but it's harder to reach the manufacturer internationally. So you're the one that might get sued. And you'd be like, I had nothing to do with this, but you're still infringing. So if you're selling something, or if you even develop something, you would have a patent attorney search for any patents that might cause some sort of infringement issue for you, and then tell you how you can design around that so you're not infringing, or just tell you, listen, it's too much trouble to start selling this, because if you make any profit, you're going to owe it to the patent holder eventually. There's also a trademark clearance. If a company is thinking of a new name for itself, it doesn't want to choose a name that's going to be infringing someone else's trademark, because you can invest a lot in the marketing, in the development of your brand, and then suddenly you have to stop using it. And it could even be 3-4 years down the road where suddenly not only can you not use your name anymore if you've invested a lot in it and people know you by it, but you might have to pay damages, lost profits to the trademark holder and such. So it's always a good idea to do that before you select a new trademark. I know a lot of companies don't, but you always run the risk that you could get yourself in hot trouble. Now, this part I mentioned is, how can you protect yourself if you're a law firm? What kind of IP rights could you have? So on the trademark side, traditionally, law firms were just names of partners, right? It could be a whole bunch of names, one name, a bunch of names. But now firms can operate under a trade name. So, the Fantastic Law Group. I don't know if that is a real one, but sounds like a good name. Somebody could use that, and they could trademark that. If you use a firm name, you have to be careful if it's just one name. If it's just your last name, you most likely will get a refusal called a surname refusal. But you can overcome that by showing that you've acquired distinctiveness over the years. Let me give you an example. Sidley Austin. It's a large firm. Most people know it. When they registered for Sidley Austin, that got approved right away. When they applied for the trademark for Sidley, that got a surname refusal, and they had to prove that they'd been using it more than 5 years, and people knew their law firm just by the name Sidley. So it's a high burden to overcome, that you have to show a lot of your marketing, a lot of your name recognition, maybe surveys to show that people recognize the name, but it's possible. And that would prevent other firms from using, even if they have the same name, from using it. And you can stop them from confusing people, thinking that they're getting this high-priced law firm when you're not. Now, copyright could be a good mode of protection for your law firm. If you have a website and you put a lot of text information on it, you put photos on there, video, you could protect all those under copyright. The general layout, look and feel of a website is not protectable, but each of those elements are. And a lot of attorneys do blog posts about different areas of the law, different cases they've been working on. It would get very expensive to protect each one, because each copyright is only around $50. If you file it yourself, that's the fee from the Copyright Office, around $50. But let's say you put out a blog every week. That can add up. After 3 months, and you have to say you have 12, 13 That's $600, $650 right there. So there's this new thing that came out last year, I believe, called the group registration for short online literary works. The name is long, but the literary works are short. It's a bad attempt, a little joke here, but you get the point. So if you put out blog posts, I'll go over this one in the next slide.
Larry, I have a lot of questions on this one for you. After you're done with this is what a lot of people want to know.
Which, on that group registration. Yeah, the next slide
yes.
is about that.
And besides that, protect your law firm. That's something a lot of people want me to talk about, and we're going to have a very big conversation about, these are common problems that law firms are facing.
Okay.
So can I ask you some questions on this now or after you finish this?
Well, let me get through the next slide at least, because it
Okay.
goes more about the blog protection. So any advertising material you create that could be protected by copyright, any graphics, you don't want people just taking that and using it. And this kind of interesting is legal briefs can be copyrighted, though it's almost unheard of. There's this one case in particular. I was actually involved with this tangentially, the case that started it. I was involved with the case. It was a joint defense group, and two of the attorneys, one of the companies was Newegg, the software developer or seller, and another was this attorney that was defending another firm. His name was Ezra Sutton. And what had happened is this Newegg and Sutton, on behalf of his client, had to, the court, they were the two defendants left standing, and the court wanted a certain briefing from them. So since it was really going to be a lot of overlapping issues, Newegg said, okay, we'll share our brief with you, but don't distribute it. Just take a couple of points from it, supply a short supplemental brief. And instead of doing that, he just copied the brief wholesale, except for a couple of factual changes for his client. And Newegg, I think, had prepared for that, and they filed for a copyright registration for their brief, and then they sued him for it, which you're not going to see. Legal briefs are regurgitated all the time. Bits and pieces of it are used in other people's briefs. So I don't really recommend going down that. I just wanted to mention it is possible if the situation arises. Now, I put this Circular 67 after that group registration because the Copyright Office has a lot of information on how to do everything, and they put these in circulars. So if you look on their website for Circular 67, you can learn all about it. Now, this is a little bit more about this one, is you can register up to 50 works.
Yeah, so I think, sorry, I'll take some questions on the previous slide because that is very important for viewers, if it's okay for you, Larry.
Sure. Do you want to guess?
Yeah, this is where, people have been asking us to talk about. So take an example, right? There are a lot of lawyers in this group over there. And one thing which I've heard about lawyers, they start this new practice, Larry, and they forget to kind of protect the logo. And I think a logo is very important for them from day one. For example, you've been my lawyer for a long time. And the thing is that for me, what I've seen is even when you surf the internet, when a product starts rocking or a law firm starts rocking, people tend to, some of them try to kind of copy and everything. Can you stress the importance to people about securing the logos and also securing basically, the copyright if they have a great design of the website, and people don't even know that they can even secure the design of the website?
Yeah, well, an interesting part about a logo is that you can trademark a logo, you can also copyright a logo. So if somebody takes, let's say you have a great graphic artist design this great logo for you, and somebody uses it for a law firm, that's trademark infringement, because
Right.
This is what identifies your services. But if somebody uses it for some other purpose, it's not trademark infringement. However, you could protect it through copyright. So it could be a copyright infringement, even if they use it for something completely different. And if the logo is what you're using as the identity, the face of your firm, people see it and they recognize this is a good law firm. I know this guy. It's important to protect that, because it's not, when I mentioned before about trademarks protecting against something confusingly similar, it's not an exact name or a logo. It can be something that is very close. It can be something that sounds like it, is spelled a little different, looks like it, but doesn't even sound like it. those are all infringement. So if the logo has a slight change to it, you can also be protected. It's an overall impression, commercial impression of whether it's infringement or not, but it doesn't have to be exact.
Right. A new lawyer wants to start his practice and he forms his corporation and everything, and he wants to have all the protections. So what kind of common protections would you recommend him to do? Trademark, copyright. Of course, there's no patent here because patent does not get involved. And trade secrets, I don't think so there are any trade secrets out here. Can you talk about this, please?
So, patent, you're not really going to have patent protection unless you're developing some product for your client or something like that. But really, you're starting your law firm. We went over the trademark protection to protect the name. You could protect the name of your firm, the logo of your firm, anything that identifies it. If you have a jingle on TV or even a slogan, let's say there's a catchphrase that nobody else is using that you came up with that's distinctive, a slogan could be a trademark. I'm just going to give you I don't really have a good example right now, but if
I'll tell you, for example, I've always seen some slogans and everything. So let's think about, that MasterCard has this fantastic saying. They said there are some things that money can buy, but for everything else, that's MasterCard. How would you think about that? That's a slogan. And
right, that's a slogan. You can protect that from trademark. Nike has Just Do It, right? So Just Do It, nobody can use that to advertise athletic apparel.
Right.
Whatever they're involved with. So if you have a slogan as a law firm, like, I don't know, we sue for you.
Right.
That's too generic. But
I think I have a great example for that. So, this is where Larry comes in and his services come in. I look at these personal injury commercials sometimes, and they have this great jingle that they create for them. I think that jingle is a fantastic example for them to look into, number one.
Right. That could be a copyright issue.
Exactly. That's a copyright. And people don't think about these things. And then someone else steals their jingle, they steal their ideas, and they copy them, and they don't even realize that that's a copyright infringement. How do I know about it? I spoke to a copyright lawyer. He said that, hey, listen, I looked at an ad that was similar to mine, and I came up with with this concept. My answer is that get your copyright in order, get your trademarks in order. Make sure that even if you're an established practice, you might be dealing with personal injury, you might be dealing with, residential closings. Bottom line is, the way I think about it is that once if you think you are becoming a brand and you're planning on basically something big in your life, make sure from the very beginning, start protecting yourself, because these things may seem to be kind of, not very important for you at this stage, but later on, I believe it can become very important. And there are a few things as usual, since it's a small break time, Anjali would like to ask you a few questions, then again, we'll carry on, Larry. So that's a usual drill at 3:35.
Sure. You said
Anjali, your questions.
Thank you. Yes, sir. Larry, I just have a couple of questions because you've been using
My legal software is tested it and everything. You can
Yeah. So I just wanted to you to share your experience about My Legal Software with our attendees, so that the lawyers who are attending or the paralegals that are attending.
Question, Larry, since you know about My Legal Software, can you tell people how helpful this has been to you since you've looked at it? You know the program very well. Have you seen anything like this? That's what Priyanjali is trying to ask you.
Yeah.
And how can help any lawyer?
What's nice about My Legal Software, it's a more extensive solution from other solutions I've seen as far as a practice management. It really, working as a lawyer and trying to manage a firm is a stressful job, and remembering everything takes a lot of energy, a lot of time. But MyLS can make it a lot easier because everything is right there. The interface is easy to use. It keeps track of, especially if you're collaborating with a lot of attorneys, you have a firm with different people that are using it, what case is assigned to who, what schedule is everybody on, what schedule of all your court proceedings, who's running to court, when. It keeps track of everyone's schedule, who's collectively working on cases, shares files, research notes, really everything's in one place. And it's available on any device too, which makes it really handy. You're in court, you don't have access to your computer, you got your phone right there. So it helps you manage and keep things running smoothly.
And Larry, so you have such a a big career in terms of like, law and everything. So I'm sure you must have used a lot of other software. So while using MyLS, how did you find it different than the other legal softwares that you might have used in the past, or, heard from other people?
Yeah, well, I think the biggest benefit is that it was developed by lawyers, right? So it's not just developed by a tech team who thinks they knows what lawyers want. This is designed by attorneys, and as far as I know, it was tested by a law firm for many years.
A lot of attorneys have tested it actually.
Right.
And the other thing is that it is good for any practice. And what I like about it is, Larry, that is, the deadlines are the key. And the other feature which I like is the mail-in feature and the mail-out feature. But then exactly the thing is, once a mail comes in, you have tracking of mails, when it came in, what happened. It has Zoom integration, it has WebEx integration, it has Google Meet integration. And also there are trackers that when your deadline comes closer, you get reminders, and you can work in groups. You can work from anywhere in the world, and it's very easy to use. And above all, a lot of lawyers like it because of the simplicity. And this is one software wherein you can self-train yourself and get going from day one.
Yeah, I think it's laid out nicely, like you said. It's, or like I mentioned, it's because it's designed by attorneys. You know what's important and what you need to see first, and everything's right there that you're really going to need, so you don't miss those deadlines, you don't miss the collaboration and such. And I like those integrations too. You don't have to go here or there to get on your Zoom to schedule a meeting or whatever. It's just right there.
Thank you, Larry. And as you know, it can be used for any practice which you would agree on, because it's like a motherboard. It's like exactly, even if you're doing divorces, you're doing bankruptcies, you can just use it and just integrate it and be happy with it. So this is more like a master board, wherein anything can be kind of plugged into it.
Yeah.
All right, so let's proceed further with your next slide. And I think you're doing a fabulous job, and I'm sure people are learning a lot.
Sure. So I thought this would be an important issue for lawyers, especially, is this group registration. I just want to tell you quickly about it. So like I was saying, it can be very expensive if you try to register every single blog post. You write an analysis about something, useful tips for people, a certain area of the law. You can put them out within a 3-month period. You put out as many blog posts as you want, and for one application fee, you can file for registration instead of paying for each blog post, which can get very expensive. There are certain restrictions, like each work must be written by the same author or co-written by the same joint authors. You can't have a bunch of different people writing them to be covered under this. But they can be big, 50 to 17,000 words. That's a long. You could write a small book. And then I just put the I told you about Circular 67. I put the web address there. It's just the Copyright Office website. Look through the circulars about any questions for copyright law, or call me. And there's a lot of information out there. Now, I just wanted to go over a little bit of my services. Since I have that engineering background, I can.
Larry, I'd like to take some questions, because viewers want me to ask you. Someone just texted a question to the team. Now, because they want things in simple, because some of them don't know anything about copyright and they don't know the differences. Now, let me make it simple for our viewers, and of course, Larry is going to talk. So anytime, Larry is a very good lawyer. Let me kind of say that, because we've also used him and he's just brilliant. So anytime, if you're a law firm and if you're looking for any kind of basically patent prosecution, Larry can help you out. If you're looking at registering your trademark, now again, I'm telling you that people forget the importance of trademark. And if you're looking at registering your trademark, and if you have this fantastic pictures that you have on your site, you have these special kind of design that you've created, best thing is to reach out to Larry. Larry, is there a phone number that people can call you?
Yes.
908-666-4663. And that's Larry's number, larry@rosenthallaw.com. That's his address. And a few important things is that anytime if you encounter a problem with copyright violations, if you even have basically, a lawsuit going on, if you get a client who has an issue dealing with kind of patents, copyrights, trademarks, trade secrets, I think, it'll be very important for you to kind of make sure that you get in touch with us or with Larry. And Larry, I think I'm having a question. Let me take some questions from viewers because
Sure.
the time is running short. Can
I-
someone else use the name of my business for their business?
Not if I can't just give you a straight up answer without knowing the facts of it. But generally, they can't do it if they're offering the same goods and services and you got there first. It's very important. If they start using it first, then they have the rights to it. But if you're the one that's been using it and then somebody else tries to use it it doesn't have to be exact same goods and services. It can be tangential. As long as it's that confusion, gray area, you have a chance of stopping them from using it.
Great. So look at such important answers and questions from Larry. And Larry is a scholar. Now there's another question. I want to add IP laws into my practice. So I want to know, what can I do if a company uses my C? So I want to add into my practice. So what I wanted to know, what can I do if a company uses my client's idea without my permission? It's a strange question, which I really don't understand really.
So I think the two questions the person has mixed. The first question that the person wants to ask is, how can I add IP laws to my practice? And the second question is, what if a company uses my client's idea without my permission? So.
Okay, the first one is, if he wants to add IP law, he should take some CLEs and everything and get familiar with intellectual property law. Take some classes and get, there's a very good school, it's Franklin Pierce Center for Intellectual Property, which is very well known for IP law, and they can go there and take some courses and work under a wonderful mentor like Larry, so get some internship training or something and practice IP law in future.
Trademark law and copyright law, you don't need any special certification. For patent law, you need to pass the patent bar, and to sit for the patent bar, you have to have a science or engineering background
right, that is
qualify for that. So it's a little bit more of a niche. I see a lot more people, a lot of let's say general business attorneys do a little bit of trademark practice.
Right.
But when they get a little complicated, that's where they come to me.
So folks, since time is running out, a few things to all our lawyers and our friends. As you all seen that we have the best of some of the finest minds coming in and talking to us on this particular subject. And if anyone has any questions, you may reach Larry Rosenthal for all your copyright, for all your trademark, patent matters at any point of time. You can reach him. And I would strongly recommend Larry. And if you want to be a speaker like Larry, come in and join us. We'll be happy to promote you. And also these videos will be promoted online. So getting that presence for MyLegal software. As you all know, MyLegal software is a case management software. As you're seeing from people like Larry who love this software. And if you want to have a demo, you can call Priyanjali at 212-390-9493. And Priyanjali, the floor is in your hands now. Why don't you talk for a few? And then again, Larry can just give us closing remarks.
Thank you, Mr. Gehi. It's a request to all of our audience. If you're a lawyer who has a good experience in the practice area, it can be any practice area. If you want to be a guest speaker, please drop me an email at anjali@mylegalsoftware.com. And we have a proper panel who can look at your resume, and we can decide on whether or not you are fit for being our next speaker. And as you be our next speaker, you get a chance to interact with our audience, and you also get a social media presence, a certificate, and
social media presence and a certificate. And Larry, you're getting a certificate from MyLegal software that you spoke at this fantastic conference with us. And your profile will be on social media. You'll be promoted. So these are the benefits of MyLegal software. And as I said, Larry was also chosen after we did a very good background search. We want to make sure that this helps lawyers. Now, how this is going to help lawyers? Now, let me come to that. The whole idea for MyLegal software is to have the network of lawyers where we all kind of join together and we make money. So now tomorrow, Larry may get a client in another state. Look at this. And Larry is going to be kind of on the website of MyLegal software. So what happens is that if someone comes across a client in your office, says, hey, you know what, I'm looking for an intellectual property. Call MyLegal software, will hook you up to Larry, or you can reach Larry. He is a part of the MyLegal software program now. So get yourself on the program. You're getting the social media presence. You're getting free marketing. Cannot go wrong with that, correct? And this is how we are building a community together. So any intellectual property, any copyright, any patenting issues, Larry, is there anything else you practice besides that? some basic stuff like forming corporations or something for people, because sometimes we get clients in New Jersey asking us, hey, I want to form a simple corporation and get started.
If a client needs a type of work, I mean, it's not what I put myself out there as, but I can do work with that, with certain contracts and stuff for clients, formations and such.
Super. So these are the benefits, and this is amazing. And I think Larry has been a fantastic speaker. And now a few important things. Next week, very, very important session coming up. And that session is going to be amazing for lawyers. And the session is about basics of family-based immigration for new lawyers, experienced lawyers, and for people who want to start and integrate immigration to the practice. Now, even Larry will tell you why immigration is important, because even Larry, you might be having clients come in and talk to you about immigration matters. So we are going to teach people of how to start your immigration practice. Or if you are not an immigration practitioner, how can you basically get new clients and grow your practice? That is next week. And it's a workshop, it's kind of a one-on-one training with actual forms and everything. So you'll understand the importance of it. That's coming up next week. And also don't forget, the week after that, we have the former president of Queens County Bar Association going to talk to you about SIJ, that's Special Immigrant Juveniles. And she's going to talk about guardianship matters. And of course, we're going to touch on adoption. Then, besides that, if you're a lawyer in another state, even if you practice personal injury, if you do closings, if you do matrimonial law, if you do divorces, if you do child custody, doesn't matter which state you're from, contact My Legal Software. And I think, Anjali, you can let them know how to get in touch with you, please.
Thank you so much, Mr. Gehi. So it's a request to all the audience, in case if you want to get in touch with us, please call us on the number 212-390-9493. You can drop me an email, Anjali, that's ANJALI, @mylegalsoftware.com. And also, I would like to take an opportunity and mention that we also provide legal mentorship to people in case if you're stuck with a form, or if you want, if you're stuck in a case and you want to know the next turn or next step that you should be taking. So we have a panel of lawyers and good attorneys who are very highly experienced, including Mr. Larry, Mr. Gehi, who will be helping
yes, so
you
let me talk about this with Larry. Isn't that a fantastic benefit which is provided? Like if they join My Legal Software, if they get stuck up with legal research, there are people in My Legal Software who do the research and get back to you with the question. They're using the legal software, plus they're getting the backup. How would you feel as a lawyer who, especially since you've been practicing for a while, can you tell us how much importance, how important this is for new lawyers, Larry?
Yeah, I mean, as a new, I'm not a new lawyer anymore, but as a new lawyer, you don't know.
Not you, about people I'm talking about.
You don't know the ins and outs of the law. And if you had a support system to, you said the research topics and such.
Research, and you get stuck up with questions sometimes. You don't know the answers,
Yeah, that's really valuable, especially if you're, trying to do it on your own. You're not going to have those resources available. So if you were using MyLS and you had those resources, that would be fantastic.
Thank you.
Thank you so much.
And Larry, your last 2 minutes or 3 minutes, so what do you like to tell people? How should they protect themselves in terms of their copyright, their intellectual property, the patents? Because people take these things very lightly.
Okay, so the most important thing to remember is do it sooner rather than later. If a client creates a product or that they want to patent, an invention, let me put it that way, an invention. It might not be a product, it might be a process, a way of doing something can be patented. And you sell it, and then a year later you want to patent it, you've lost all rights to it. Once it's sold, offered for sale, or disclosed to the public, the US legal system gives you a 1-year grace period to file that patent. Otherwise, you've lost it forever. And if you want to sell it internationally, you better do it before, you better file for a patent application before you reveal it at all, because you might not get, certain countries don't give you any rights at all if it's been publicly disclosed before your filing date of the application. As far as trademarks, you don't want to go in and start using your name, using something, a symbol, a logo, and then have to stop using it. And if you want to start using yours, and then let me give you the example here why earlier registration is more important. Is that, let's say you start using your name, 2 years down the road, you decide you want to get a federal registration because you just thought about it. Somebody mentioned it to you. And you go to Federal Register, but somebody who had started a year ago, you might have those rights, but they got to the PTO first. The USPTO is going to see them on the register, and you're going to have a harder time getting your registration. You have to bring legal action to cancel their registration and such before you can get a registration. So you want to be the first one to go there. You might, like I said, you might still have absolute rights to it, but it's going to be a headache if you don't have those rights early.
Thank you so much, Mr. Larry, for your advice and words. I hope all the attendees who have attended the webinar and people who will see this session in future will make notes, and the session is going to be very helpful for them. And thank you, Mr. Gehi, for such a wonderful
few
session.
things next week, very important, and especially this is great for new lawyers, ABCs of family-based immigration, perfect for people who want to start an immigration practice, perfect for new lawyers. And remember, if you need a demo, you can get in touch with Anjali, and she can schedule a demo for you for My Legal Software, and she'll let her do the talking, and then we can leave accordingly. And thank you, Larry, for being here today. This was very informative. This was fantastic. And if any, as I said, well, your entire portfolio will be kind of promoted on social media. And at the same time, people who call My Legal Software, you'll be on a recommended list of attorneys. But then if someone talks about intellectual property, trademark, we'll definitely be referring those matters to you.
Well,
Anjali,
well, thank you, Anjali. Thank you, Mr. Gehi, for allowing me to inviting me to present today. I hope it was useful, and
you did a fantastic job. And Anjali, about how can people reach you for demos? As Larry said, please, you can finish up the closing round accordingly.
Thank you so much, Mr. Gehi. So if you're looking for a legal case management software, and if you're stuck with organizing your paperwork or your team and your documents and anything, the court dates and all of that, so we actually provide a 360-degree solution for all your legal needs. It can be a calendar, it can be resources, it can be your team collaboration, it can be your audits, or it can be your forms if you're an immigration lawyer. So all of these features, and including the integrations, like Mr. Gehi spoke and Mr. Larry spoke, that we also provide integrations with Zoom, Card Knocks, and number of other.
There's one benefit I like is about the integration with basically the credit card terminals. The good thing is that your client pays the credit card processing fee, so the entire software may turn out to be free for you. That's one use. And secondly, if you're struggling with your staff, you have lawyers from foreign countries working for you at a fraction of the price who are absolutely brilliant instead of hiring a paralegal. Take an example, you cannot find a good paralegal. How about having a lawyer who's trained very well in a foreign country with experience coming and handling your paralegal matters? What do you say about that, Larry? Isn't that great for virtual? And plus the person is online with you.
Yeah, that's right. I mean, you get that quality at that price. It sounds like a win for the clients and the firm.
Thank you. And yes, thank you, everyone. And we'll be back again next week, same time, same place. Remember, next week, again, and you're getting a hands-on training on how to start your immigration practice with family-based immigration. Or if you're a new lawyer who wants to add immigration to your practice, you're a real estate lawyer. And remember, this My Legal Software has two specialized products. One is GP Speed, which is meant for any and every general practice lawyer. Immigration Speed is meant for immigration lawyers, and they have custom forms and everything you could think about. Try it, and after that, you may proceed further. Thank you, Anjali. And please, and if there's anything else you'd like to say, so we can close within 1 minute from now.
Thank you so much, Mr. Gehi. Thank you so much, Mr. Larry, for joining us today. And I hope everybody enjoyed the session today. And please visit our website, mylegalsoftware.com, for having more, if you need any more information about the software or our products or our team.
Even if you want to get in touch with Larry, and please don't forget to honor Larry with the certificate of appreciation, and make sure that you send that on the site.
Sure. Thank you so much, everyone, for joining us today. I hope you have a good rest of your day, Mr. Larry, Mr. Gehi. Thank you so much.
Thank you.
Thank you.